1, 2, 3.
To the students and test, test, test.
Ah, yeah, indeed, I can hear.
Yeah.
Indeed, yeah.
Yes.
Good afternoon. Good afternoon, everyone. Can you hear me? Good afternoon, everyone. Can you hear me well? Thank you. Good afternoon, everyone. I hope you can hear me well. If you don't, please raise your hand. I'd like to make sure that everyone can follow the lecture. So we are starting. Good afternoon. I'm delighted to be here today as your next law lecturer. My name is Amira Aksaferi, and I will be delighted to teach you today and tomorrow on two fascinating topics. The first one focuses on a phenomenon that EU law has long treated as largely theoretical: disintegration, the possibility that membership might be reversed. And Brexit is the first and so far only case in which a former member state of the European Union has left the Union using a treaty procedure. In today's lecture, we will approach Brexit through a legal lens. This means that we'll be less concerned in political dynamics and political discourse and more interested in the legal architecture. Therefore, the question puzzling us and underlying today's lectures are: who has the authority to decide for leaving the European Union? What procedure does EU law require? What happens to rights and obligations once withdrawal begins? And before zooming in on today's lecture, I wanted to give you a bit of a glimpse of who am I. So I provided you in the slide a number of pictures of the cities where I have studied and lived and worked. I am a lecturer in European law at the Department of European Studies at the Faculty of Humanities, where I'm engaged with teaching and some research on a variety of topics. Those which are dear to my heart, with which I engage in both teaching and research, are enlargement of the EU, the role of the EU as a global actor in the wider world, delegation of powers in the European Union and its implications in the institutional balance of the EU. I studied law in my home country, Albania, where I qualified as a lawyer and practiced law for a few years. And like you, very much curious and driven by my passion to explore the world and deep dive into the EU legal order and international legal order, I pursued my studies in law and economics in Germany, in the Netherlands, and later I pursued further studies in international European economic law in Maastricht, where I also finished my PhD studies on the topic of delegation of powers in the European Union. And since January 2020, I am a member of the law section at the Department of European Studies. What is the scope of today's lecture? So let me start by mapping the outline. We will begin with a broader idea of withdrawing from the European Union, what it means constitutionally for European integration. From there, we zoom in on Article 50 of the Treaty of the European Union, which is the legal basis, the legal gateway for a member state to exit the EU. Article 50 first concerns the decision to withdraw. But who takes the decision at national level? What counts as valid notification to leave the European Union? And what these steps means for the leaving member states and for the Union. Once the decision has been made and communicated, Article 50 then moves into a second layer, into a second phase, which concerns the negotiations for withdrawing from the European Union. Here, the focus shifts from the member state's choice to the EU's structured process, how the Union negotiates, which are the institutions involved, what are the timelines, what the withdrawal agreement foresees. And finally, we'll look into the external dimension of leaving the European Union. Withdrawal, as you'll see in the following slides, is not only an internal EU constitutional question. It also reshapes the position of the leaving state in international law. Its treaties, its trade relations, regulatory cooperation, and the practical implications of operating now outside the EU legal order. On 23rd of June 2016, the voters in the UK, by a slim majority of only 4%, decided that the United Kingdom should leave the European Union. This was a major earthquake with political and economic aftershocks going beyond the white cliffs of Dover. And the decision was made through a national referenda. Now, referenda are frequently perceived as epitomes of democracy. In a perfect world, well-informed citizens representing the entire society are expected to make key informed decisions affecting the future of their countries. And their decisions on what to vote for should be based on a thorough consideration of arguments and facts that are objectively argued. However, the voters who casted their votes have made their point clear, and the UK, whether accidentally or not, was heading for an EU divorce. And this was confirmed by the letter of then Prime Minister addressed to the President of the European Council regarding the decision made by the United Kingdom through a referendum to leave the European Union, a letter addressed on the 29th of March, 2017. Certainly, this result did not follow without contestations. Opponents of memberships argued that there was both insufficient input legitimacy with regard to the outcome of the referenda in terms of insufficient control by UK voters over the outcomes of the referenda, and also insufficient output legitimacy, arguing that the substance of EU law was undesirable for the United Kingdom. Regardless of these contestations, after having obtained the necessary authorization from the Parliament of the United Kingdom, the government started the process of leaving the European Union, which finished in January 2020. It's almost 6 years ago. And the formal notification, using, for the first time in the history of the European Union, Article 50 for a member state to exit the Union through a treaty procedure, dates back to March 27. But let's take a step backward and question. The right of withdrawal from the European Union originates from the treaties, or does it originate from the past? For a long time, EU law developed under the assumption that integration of the European Union was one-directional. And the idea of withdrawal was theoretical, certainly debated in academic literature, occupying the works of scholars. A withdrawal clause was actually drafted in the draft constitutional treaty, which was a European project for European constitution, which the idea of which was abandoned as a result of failed referenda in some of the member states. And that withdrawal clause, which was then contained in the draft European Constitution, was later codified in the Lisbon Treaty, as it is now Article 50 in the Treaty of the European Union. And that provision was aimed at ensuring that if exit ever happened, if it was ever invoked by a member state, it would happen only through a treaty procedure. However, no member state invoked it until Brexit. There is no precedent of a member state withdrawing from the EU. However, you could come across some discussions about the illustrative example of Greenland, whose population decided by referenda to withdraw from then European Community in 1982. However, this example is partly relevant to the conversation, the context of Brexit, because Greenland was not a member state, but only part of a territory of a new member state, Denmark. And for that reason, the withdrawal of Greenland was only made possible through a treaty amendment with the agreement of all the member states and of the EU institutions. The treaty was subsequently ratified by the legislators of the other member state in 1984, opening the way for Greenland to leave the European communities only in 1985, setting a precedent for the UK more than 20 years later. So Brexit, in that context, matters because it transformed Article 50 TU from a theoretical safety procedure into a real constitutional procedure, and it constrained, therefore, the EU to interpret, apply, and politically manage the procedure for leaving the European Union under strict conditions. Under the current treaty, it is indeed Article 50, the main legal basis which informs the procedure of a member state wishing to leave the European Union. Paragraph 1 of Article 50 establishes what we could call as a principle of state autonomy, because it recognizes that any member state may decide to withdraw from the Union in accordance with its own constitutional requirements. So the use of the verb may indicates that it is indeed a discretionary choice of a member state to make this decision on its own, and it should do so following their own legal requirements, which are prescribed in their highest act, their own constitutions. The treaties, therefore, do not prescribe whether the decision must be taken by referenda, by parliament, or other means. So the question is left to domestic constitutional law to regulate. Paragraph 2 of Article 50 then turns the domestic decision into an EU law procedure. Once a state decides to withdraw, it must notify the European Council. Only after notification, withdrawal becomes a structured process. The European Council provides guidelines, and the Union negotiates and concludes the withdrawal agreement with the departing state. The agreement is concluded by the Council using qualified majority, but only after the Parliament has given its consent, which means that the Parliament has to agree, but it could potentially disagree. So the process, as you may see, is not purely intergovernmental with the Council and with the departing member state. It is legally framed and it is institutionally controlled, especially with the involvement of the Parliament, which has also a role in the process, given its right to consent, as recognized by paragraph 2 of Article 50 of the Treaty of the European Union. And finally, paragraph 3 of Article 50 sets out the time frame. The treaties will cease to apply for the withdrawing member state either on the entry into force of the withdrawal agreement, or in the event it happens that no agreement has been concluded within the 2 years time frame, 2 years after the notification. However, as you might recall from the Brexit case, the 2 years time frame could be extended, but only if the European Council unanimously agrees in agreement with the withdrawing member state. This creates both a default legal endpoint and a built-in pressure towards an agreement. So, in summary, Article 50, paragraph 1 and 2 combine a constitutional decision, a formal notification, an EU-managed negotiation, and strict timelines that shape bargaining power and strategic choices. Now, looking back at Article 50, paragraph 1 and 2, which speaks of the procedure, the question arises as to whether there are conditions which could apply to a withdrawing member state. And by looking at the text of Article 50, paragraph 1, one could conclude that Article 50 sets no substantive conditions for the withdrawing member state. Specifically, the United Kingdom did not have to justify withdrawal to the EU institutions. The legal question was whether the decision that was taken was notified correctly. Therefore, the withdrawal is voluntary, so it is left to the member state to conclude, and unilateral. The member state decide, the EU cannot veto that choice. Hence, the choice is unilateral. And that confirms that membership to the European Union is based on consent, not on coercion. Of course, once the decision is made, the terms of withdrawal are negotiated. So unilateral decision to leave does not amount to unilateral outcome. Thirdly, if we look at the Article 50, we notice that the withdrawing member state is also not bound to give reasons for leaving the Union. And this is unusual, seeing it from a EU law angle, this is a bit unusual for a legal system that often requires justification, proportionality. But Article 50 treats the reasons as politically relevant, but not legally necessary for a state to justify its withdrawal. Again, Brexit is illustrative. Arguments about sovereignty or regulatory autonomy matter politically, but they were not the legal preconditions for triggering Article 50. Finally, the withdrawal must comply with the constitutional requirements of the leaving member state. Therefore, we could argue that Article 50 exports the legitimacy question regarding the choice made to domestic constitutional law. The Brexit process itself demonstrates why the UK Supreme Court, as we'll see in the following slide, in the Miller case, centered on who had the authority under the UK Constitution to trigger withdrawal, the Parliament or the government alone. And the answer mattered because Article 50 assumes a valid decision at national level before the EU procedure begins. So Article 50, paragraph 1, makes withdrawal legally available with minimal conditions, but it justifies legitimacy in national constitutional law and then move the real discussion into the negotiation phase. The withdrawal procedure itself is set out in paragraph 2 of Article 50. The first step is simple. A member state should formally notify the European Council of its intention to withdraw. It starts the process, and crucially, within 2 years, time frame should bring it to completion, following Article 50, paragraph 3. In the Brexit case, notification took the form of a letter sent by the UK Prime Minister to the President of the European Council in March 2015. It was precisely this letter you see on slide which marked the formal notification process of the European Union. As far as the formal notification is concerned, as to the form of the notification, Article 50 is silent. Secondly, treaties give no detailed instruction on the form of notification. And that raises question about clarity, about revocability, about authority. Brexit triggered precisely this kind of question. Could a state withdraw notification and stop Article 50 procedure to notify its intention to leave the European Union? The Court of Justice later confirmed that unilateral revocation is possible, but under strict conditions. And that means that provided it is done in accordance with the constitutional requirements of the member states and before the withdrawal takes effect, which is exactly the 2 years time frame, or within the extended period, in case the European Council and the member states have decided to extend the time frame beyond the regular time period which applies for a living member state. Once notification happens, the European Council adopts guidelines. These guidelines, even though they are not hard law, but soft norms, soft rules, they are not just political theater. They set priorities, timelines. During Brexit, for example, the European Council insisted early on the issues like citizens' rights and financial settlement to be addressed before moving to the future relationship with the UK, soon to be a third country. And that illustrates how the European Council steered the negotiation without itself negotiating line by line the provisions in the withdrawal agreement. Finally, paragraph 2 in Article 50 frames the agreement as a withdrawal agreement that must take account of the future relationship with the EU. Now, this wording is important because it tells us that withdrawal is not only about closing the door to a former member state, but also about defining what comes next. Trade cooperation, security cooperation, defense, and so on and so forth. So Brexit, again, is the obvious illustration that the withdrawal agreement handled separation issues of a member state from the Union, while the longer relationship with the European Union was developed in a separate instrument. The withdrawal agreement, to which Article 50 refers, is an international agreement. And my colleague Matteo walked you through last week into the steps and procedures established in the treaty regarding the negotiation and conclusion of an international agreement by the EU and the member states with now a third country. The withdrawal agreement must be negotiated in accordance with the provisions set out in the treaty, which applies to all kinds of international agreement, and they are established in Article 218 in the Lisbon Treaty. The withdrawal agreement, as every international agreement, begins with a recommendation by the Council. So normally, from the European Commission, or in policy areas like CFSP or CSDP, from the High Representative. In the Brexit context, it was certainly the European Commission which had that authority and prepared the negotiation setup and acted as the negotiator on behalf of the European Union with the UK. Next, paragraph 2 provides for the Council authorizing the opening, the formal opening of the negotiations and adopting negotiating directive. Essentially, it's the EU's mandate, timelines, terms and conditions, and red lines. During Brexit, this directive matters because they establish political priorities from the outset. Paragraph 4 of Article 218 provides for the Council appointing the Union negotiator and a special committee to oversee the course of negotiations. Think of this as a structured channel through which the member states monitor the negotiation process. The Commission negotiates, but the member state remain close to the table through their committees composed of national representatives watching and reporting back to the Council about the progress of negotiations and the points in the agenda discussed among the negotiating parties. And once the text is ready, the Council will authorize the signature of the agreement. And this is the point where the EU signals externally. We have a text we are willing to sign, even if final approval still depends on the Parliament giving consent. Brexit provides a concrete example of why this procedure matters. So even after the negotiators reached a political agreement, the withdrawal agreement still required the consent of the European Parliament, which means that the Parliament had to agree, had to give its consent, had to consent to what was already established in the text by the negotiating parties. And paragraphs 10 to 11 of Article 15 remind us of two additional safeguards. One, Parliament must be kept informed about the negotiations, and the Court of Justice could be asked for an opinion on the compatibilities of the international agreements with the treaties. However, this safeguard was not used in the case of Brexit. So, from the text of Article 50, we understand that Article 50 triggers withdrawal of a living state from the Union, but Article 218 informs the EU's internal decision-making procedure in terms of who mandates, who negotiates, who signs, and who give the final green light for an agreement to come to conclusion and start its legal effects. The decision to conclude an international agreement, and in the present case, the withdrawal agreement, was taken by the Council of the EU following the consent of the European Parliament. The European Parliament gives its consent by a majority of the votes cast. Only if the Parliament agrees by giving its consent, the Council can conclude the agreement with a super qualified majority of the remaining member states. Now, Article 218, paragraph 3, letter B, requires special qualified majority for decisions under Article 50. That means that 72% of the remaining member state, representing 65% of the population, must vote in favor. This voting requirement aims to prevent a small coalition from blocking the collective position of the Union in a withdrawal agreement, while still requiring broad support. The procedure also brings together the Council and the European Parliament. So supranational institution next to an intergovernmental institution in the process. So as indicated earlier, this process is not entirely intergovernmental. And the Parliament, though involved only with the right to consent and be kept informed throughout the process, plays a role. Can a withdrawing member state still participate in the voting procedure? Can the members of the European Parliament from the withdrawing member state still vote in plenary? Article 50, paragraph 50, paragraph 4, does not exclude the members of the European Parliament. And in the case of Brexit, the members of the European Parliament who represent the UK continue to sit and to vote in the European Parliament until the withdrawal agreement took effect, including during the period when the agreement was being debated until consent was given. And finally, ratification of the withdrawal agreement by the remaining member states is not required, which is in line with the voluntary nature of the withdrawal and certainly speeds up the process. From the moment of formal notification, the EU and the member state and the withdrawal member state have 2 years to reach an agreement on the withdrawal. At the end of the 2 years, which is envisaged in paragraph 3 of Article 50, if no agreement has been reached between the EU and the state, the EU membership come to an end, unless the European Council decides unanimously in agreement with the withdrawing state to extend the deadline. An important aspect of Article 50 procedure is that it starts a 2-year countdown during which a withdrawal agreement must be concluded. And this time limit can only be extended by unanimous decision of the European Council and the withdrawing member state, as per paragraph 3 of Article 50. The purpose of the time limit is a way to put pressure on the withdrawing member state to come to an agreement with the European Union and not keep the entire Union in a state of uncertainty for too long, as if with regard to question about what's going to happen with a state which has communicated its intention to leave the European Union, and how this could shape the relationship with EU and with third countries. According to paragraph 3 of Article 50, from the date of the entry into force of the withdrawal agreement, or failing an agreement, 2 years following the withdrawal notification, unless there is an extension of this period, the EU treaties and the protocols attached to the EU treaties, namely the TEU, the TFEU, and the Charter of Fundamental Rights, shall cease to apply to the state concerned, in the present case, the UK. While EU law ceases to apply in a member state, once it leaves the European Union, national acts adopted in the implementation of or transposition of EU law would remain valid until they are repealed or amended by national legislation. The rights and obligations deriving from the treaties would cease to apply at least to the extent agreed between the EU and the withdrawing state in the withdrawal agreement. International agreements between the EU and third countries, or international agreements, will also no longer apply to withdrawing state, which would have to negotiate alternative arrangements with the signatories to those agreements. Is Article 50 foreseeing notification of a member state to withdraw a one-way door, or can it be reversed? Now, Article 50 itself is silent on the possibility to revoke notification regarding the intention of a member state notified to the European Union, to the European Council specifically, to leave the European Union. So given that Article 50 is silent, the question, which was raised also in the case of Brexit, was approached through international law, and specifically through the Vienna Convention on the Law of the Treaties, which allows withdrawal of a notice before it takes effect. The EU treaties are a special constitutional order, so you have to ask whether EU law operates as a lex specialis that that prevails or displaces general rules under international law. A second line of argument was political institutional. Even if Article 50 is silent on the matter of revocation of notification, the other member states acting together could unanimously extend the 2 years period. However, the legal clarification came from the Court of Justice in the Whiteman case in 2018, which I will discuss with you today. In that case, the court held that a member state may unilaterally revoke Article 50 notification without needing the approval from the EU 27 member states, but only under strict conditions. The revocation must be unconditional, unequivocal. It must comply with the own constitutional requirements of the leaving member state, and it must occur before the withdrawal takes effect, which is 2 years. In other words, the court allows for a possibility of the withdrawing state to change mind under strict conditions, but does not allow a tactical ambiguity. Therefore, sets those conditions. So, the deeper constitutional question to keep in mind is why allowing unilateral revocation protects self-determination, but it also raises concerns about strategic use of the notification as leverage in negotiations with the European Union. Before moving into the case law of the Court of Justice, discussing exactly those questions which were unclear until the court ruled them using the preliminary ruling procedure, since Article 50 was not used until Brexit, and therefore some questions were unclear and posed the need for legal interpretation at the time by a British court. I wanted to ask you if you have any questions before we take a 10 minutes break. Questions or comments or reflections? In case there are no questions for the moment, then we could take a 10 minutes break and then we can continue with the lecture afterwards. So we can go ahead. Can you hear me well? I'm trying to see if the micro works. I think it works. Can you hear me? Yeah, I'm trying to see if the microphone works for the recording. So, as suggested, there were many unclear questions regarding the application of Article 50, and certainly this is not surprising. The reason being that the EU and the member state involved, the withdrawing member state, namely the UK, found themselves puzzled by questions, the answer of which was unclear, especially in the context of a referenda which triggered contestation given the slim difference of 52% of those who voted to leave the UK against 48 which voted against leaving the UK. So the difference was really slim. Therefore, in 2017, right at the time when then Prime Minister of the UK notified through a written letter the European Council about the intention of the UK to leave the European Union, a group of elected representatives brought a challenge before the Court of Session in Scotland. The petitioners included also two members of the Scottish Parliament, Andy Whiteman and Ross Greer. So that's why the case named after him, so known also as Whiteman case, naming after the names of the petitioners. Together with three members of the European Parliament and one member of the Parliament of the UK. Their aim was not to relitigate the referenda. It was clear that the decision made was final, but their intention was to clarify a legal uncertainty with constitutional implications. Once Article 50 has been invoked, is the process reversible legally? So does Article 50 allow it? From the text of the treaty, it was unclear because the article was silent. Therefore, they asked the National Court to make a reference for a preliminary ruling under Article 267. And I wanted to ask you, to the best of your knowledge, what does the preliminary ruling procedure under Article 267 TFEU foresee? Why did they ask the National Court to put the case on hold and submit the question for interpretation to the Court of Justice in Luxembourg, so that the National Court and the EU Court would engage in a so-called judicial dialogue with regard to the question concerned for interpretation through the lens of EU law. So again, the question asked to the court was, once Article 50 has been invoked, could it be reversed? Why they asked the National Court to use the preliminary ruling procedure under Article 267? Based on what you have learned so far. Please don't be shy. Whatever opinion you might have, feel free to suggest it, and we can discuss it together. If you open the treaties under Article 267, what are you going to read? What can you find in the text of that provision? Can you take 2 minutes to read Article 267 TFEU? What does that provision foresee? Was it a legitimate request, those of the petitioners, to ask a national tribunal to put on hold the proceeding and submit a question for interpretation to the Court of Justice in Luxembourg using Article 216 TFU? And to answer that question, you'll have to look at the text of Article 267, which actually will give you a clear perspective of what the requirements of that article are and its scope of application. Any suggestions? So, indeed, the question put forward concerned an article in the treaty which could only be interpreted by the Court of Justice of the European Union, which has the exclusive jurisdiction to interpret matters pertaining to EU law. And the petitioners were aware of it. That is the reason why they used this procedure in order to have the Court of Justice involved in some kind of a judicial dialogue with the national court to answer that question. That is a requirement which follows from Article 267 TFU. National judges are not involved with questions pertaining to the legal interpretation or validity or invalidity of any legal act that falls under the exclusive jurisdiction of the Court of Justice of the European Union based on Article 267. So they were right to ask that to the national court. So they asked the national court to make a reference for preliminary ruling under 267. And the national court's question as to whether Article 50 procedure could be reversed goes straight into the heart of Article 50, the text of which is silent on the matter. So if a member state has notified its intention to withdraw, does EU law permit unilateral revocation? And if so, under what conditions and with what legal effects for continued membership? The Court of Justice heard the case as a full court. So all the judges were sitting to hear the case. And a full court suggests the constitutional importance of this case, not only for the withdrawing state, but for the EU law, for the EU legal order. The question put forward to the Court of Justice framed a central choice point for Brexit, whether Article 50 is a one-way mechanism or whether EU law allows a member state before withdrawal comes into effect to change course through a legal valid act of revocation, which would be a unilateral act. The court answered sound and clear to the questions put forward for interpretation by the Court of the UK through Article 267. And I discuss the findings of the case with you by referring to the exact paragraphs in the ruling so that you connect the legal reasoning of the court with the actual paragraphs in the ruling. In paragraph 73, the court draws a clear temporal boundary. A member state may revoke its Article 50 notification as long as, which means provided that, on condition that withdrawal has not yet taken effect, which means has not yet entered into force. As a result, it should be before the 2 years time frame or longer in case the 2 years time frame has been extended by the European Council. That means either before a withdrawal agreement enters into force, or if no agreement is concluded, before the 2 years period expired, including any extensions. Within that window, the member state retains the right to revoke unilaterally, so on its own, the member state can decide to withdraw the notification to leave the European Union. But the court tied that power to one crucial condition. Revocation must be carried out in accordance with the own constitutional requirements of the member state, which means with the requirements set in their constitutional law, in their constitutional legal order. So the court tries to protect democratic self-determination, but anchors legitimacy in constitutional law. Then subsequently, in paragraph 74 of its judgment, the court sets the form and quality of requirements for a valid revocation. The court requires that revocation must be submitted in writing to the European Council. So it's formal, can be verified, and it is institutionally addressed to the Council. Second, the revocation must be unconditional and unequivocal. These two conditions shed light on the court's way of preventing strategic ambiguity and tactics from a withdrawing member state to bargain. Revocation, said the court, cannot be used as a bargaining chip, something like, we revoke if you give us better terms. The purpose must be to confirm continued membership to the European Union on the same terms, and the legal effect is final and decisive. And the valid revocation brings the withdrawal procedure to an end. So the main takeaway from these two paragraphs of the judgment of the court point to Article 50 notification being not a one-way door, but revocation is only possible before exit takes effect, and only if it is constitutionally valid, formal, and unconditional. Subsequently, in the following paragraphs, the court explains why unilateral revocation makes sense as a matter of treaty requirement and not just political convenience. The court looked at the travaux préparatoires, which means that the history of Article 50. And as mentioned earlier in this lecture, I emphasize that Article 50 was born, so the text of Article 50, codified in the Lisbon Treaty, was born for the first time in the draft European Constitutional Treaty. And because the project was abandoned, it was later codified in the Lisbon Treaty. So the court looked at the origins of Article 50 and travaux préparatoires of the draft European Constitution. And the court stated that Article 50 largely reproduces the withdrawal clause drafted in then draft treaty establishing a constitution for Europe. When that clause was negotiated, proposals were made to harden the procedure. For example, by introducing mechanisms that would make withdrawal more difficult, harder for a member state, or by addressing potential abuse by a withdrawing member state. And the drafting record showed that those proposals were rejected precisely because the clause was intended to preserve the voluntary and unilateral nature of the decision to withdraw from the Union. So les travaux préparatoires, the history preceding Article 50, supports an interpretation of that article in which a member state remains in control of its decision up to the moment withdrawal takes effect. Subsequently, in paragraph 71 of its ruling, the court reinforces that interpretation by referring to the Vienna Convention on the Law of the Treaty, which is international law. It's an international treaty signed also by the European Union, so it's an international agreement which is part of the EU legal order. So the court referred to that and supported further its interpretation on Article 50, referencing to the Vienna Convention on the Law of the Treaty, particularly the rule that a withdrawal notification can be revoked before it takes effect. So revocation is not an exception which was invented for Brexit, but it is presented as consistent with the drafting intention behind Article 50 and in line with the general treaty law under the Vienna Convention on the Law of the Treaties. The court strengthened that the right to revoke is unilateral and does not depend on unanimous consent from the European Council. Unilateral means that it is the right of the member state involved to decide alone, without asking for approval from outside actors or institutions. And this is constitutionally important. If the 27 EU member state could veto revocation, the sovereign choice of the member state would become conditional on external approval. So the court avoids that. But the court also suggests for 4 cumulative safeguards. Think of them as guardrails. First, revocation is only possible before withdrawal comes into force. So either before the withdrawal agreement comes into force or before the 2 years time frame expires, including possible extensions, which were granted to the UK, because the withdrawal agreement with the UK could not be concluded within the 2 years time frame, and as a result, the Council unanimously decided, with the agreement of the withdrawing member state, to extend it further, to conclude terms and conditions of the current withdrawal agreement. Second, the second condition provided for the revocation to be notified in writing to the European Council. Third, to be unconditional and unequivocal. And fourth, to confirm EU membership on unchanged terms. Revocation can only be notified after the member state has taken a decision in accordance with their constitutional requirements as laid down in their constitutional order. So the legitimacy check lies with the withdrawing member state. And finally, the court adds practical but slightly unsettling implication in its legal reasoning. Revocation does not prevent a member state from notifying again later. So in principle, a state could revoke today and re-notify tomorrow. So the court's answer is basically EU law cannot remove that sovereign right, but the safeguards are meant to prevent tactical ambiguity in the revocation itself. And a concrete way to illustrate this is the following. So imagine a change of government or a second referenda during the 2-year period. The court framework allows the state to reverse course without turning a revocation into a bargaining tool. On the left side of the slide, you have an overview of the Brexit timeline, a process which started in 2016 with the UK voting to leave the EU, followed by the formal intention notified by then UK Prime Minister, the European Council, to leave the European Union, at the time Theresa May. In 2017, the EU 27 member states met to discuss the terms and conditions of the withdrawal agreement. And the Brexit negotiations, so the terms of the withdrawal agreement were expected to finish in 2009, by that time, with the UK expected to leave the European Union. So the problem in the case of the UK was the timing, 29th of March 2019, which was a default exit date, 2 years after the notification was activated by then Prime Minister May. And yet the Parliament in the UK repeatedly failed to approve the withdrawal agreement within the deadline. So after the agreement was agreed at EU level, was required to be ratified, to be approved at national level by the Parliament of the UK. And so the Parliament failed to approve the agreement before 29th of March 2019, which marked the expiry of the 2 years timeline, which is a condition for the withdrawal to produce legal effect. And this is a good illustration of the tension arising from Article 50. So EU law sets a hard clock, but domestic politics can move much more slowly. At this point, the Whiteman case becomes relevant. The court had clarified that revocation was legally possible, but under strict conditions. And in reality, the UK did not revoke, but instead the system used the other safety net in paragraph 3, Article 50, which was extension. So the European Council and the UK agreed to extend the withdrawal period following failures in the Parliament of the UK, showing that even when revocation is legally available, the more politically feasible move may be to extend negotiations. So post-Whiteman, there were two options for the UK, either unilateral revocation, following failures in the UK, in the British Parliament, or extension by unanimous agreement of 27 member states, which was procedurally straightforward but politically costly. However, in the case of the UK used the second option, so extension by unanimous agreement. If a state leaves, can it simply come back later? And how? The treaties answer this question loud and clear. Yes, a state which leaves the EU can come back, but not automatically. The state leaving the EU will be granted the status of a third country, and as a result, will follow the exact requirements and procedure as other third countries which are in the accession process to join the European Union. So in practical terms, that means that first, rejoining the Union is negotiated. The state would have to agree terms with the Union, chapter by chapter, policy area by policy area, as all other potential candidate and candidate countries to join the European Union. Second, the state, the withdrawing state, must satisfy the accession criteria, which are political, legal, and economic, as listed in the Copenhagen Declaration. And third, as probably you may know, accession requires unanimity in the Council. That means that the 27 member states must all agree for a new country to accede, for a candidate country to accede to the European Union, provided they have met the procedural and substantive criteria laid down in the treaties and in numerous political documents produced by the European Union. So a previously withdrawn state could actually be in a disadvantage compared to third countries which are in a process to accede to the European Union. And the disadvantage lies with the fact that a previously withdrawn state could face stricter conditions than before. For example, opt-outs or special arrangements that existed during earlier membership, might not be an offer. And the state may be expected to demonstrate long-term commitment. So, formally speaking, the treaties will keep the door open, but they do not provide a return ticket, so to speak, to a previously withdrawn state. And the last say lies with the member state in the Council required to vote unanimously. And as you'll be seeing tomorrow in the lecture, which we change lenses by discussing European integration through enlargement. The enlargement process is severely political and very much contested and debated at union level by some member states who are quite skeptical about enlargement versus those who have a more positive who are more optimistic about the idea of an enlarged union. So once leaving the EU, certainly it becomes harder to regain the trust of the member state for joining again. What happens after a member state leaves the European Union? Are there any implications for their legal order, considering that up until that moment, their national legal order was required to be fully compliant with EU law in light of the principle of supremacy and direct effect, which requires that EU law prevails over national law, that EU law applies directly to the national legal order. So what actually happens with those requirements? What actually happened to the UK in that case? So first, many advantages of membership come from the EU's network of agreements with third countries. And after withdrawal, the former member state cannot simply inherit those agreements that they have signed with the EU, so agreements that the EU signed alone or agreements that the EU and member states signed, known also as a mixed agreement. In practice, after leaving the EU, the withdrawn member state has to negotiate continuity of agreements to replicate as far as possible with third countries and international organizations. This is easier in some areas than others. Where the EU agreement is bilateral, mixed agreement, meaning that both the EU and the member state are contracting parties, are signatories to those agreements in policy areas where the EU and member states shared competence together. So legal certainty may require renegotiation or at least a joint protocol clarifying whether and how the agreement continues to apply to the former member state. So the key point for you to remember is that mixed agreements create complexity because there are multiple parties involved. Thirdly, the picture is often more stable for multilateral frameworks. Leaving the European Union usually does not affect states' membership in international organizations such as the United Nations, NATO, or the World Trade Organization. Those memberships from the withdrawn state are independent of membership to the European Union. But what can change is the practical role the state plays, especially in areas where the EU previously spoke or acted for it. And finally, do not overlook the position of third states and international organizations because they may need to be formally notified, and in some cases, they must consent to adjustment and changes, sometimes through additional protocols. So leaving the European Union requires the departing state to rebuild treaty relationship with third countries and international organizations. Now, reflecting on the past developments until now, building on the notion of even closer union followed by Brexit, what are some of the reflections you could share? So we began with the idea that the treaties describe European integration as a project of even closer union, which is a constitutional narrative of continuing cooperation and deepening integration. Brexit, though, suggested us to test the limit of this narrative. In the earlier slides on Article 50, we saw that EU membership is not legally irreversible. The treaties contain an exit clause with a clear procedure, with strict timelines and institutional controls. We also discussed how the court in the Whiteman case clarified that even after notification, a state can still revoke under demanding and strict conditions. So doctrinally, Brexit made reversibility part of the EU's lived constitutional reality. But the bigger point is what happened after that legal clarification. The EU's response has not been a choice between integration or collapse. Instead, we see managed differentiation, deeper cooperation in some areas, flexibility and variation in others, and after withdrawal, structured cooperation with the former member state, now as a third countries, like the UK. And that connects to the external dimension angle. Leaving the EU, leaving the European project, does not remove interdependence. It reorganizes it. United Kingdom, European Union relations now operate through sector-specific agreements and governance mechanisms, rather than through direct effect, primacy, and the institutional and legal framework. Brexit showcased that EU constitutional law contains both an integration side, even closer union, and a plurality side, differentiation and even exit. While cooperation often continues because the underlying economic and regulatory interdependence remains. Taking a pause and reflecting on our conversation. What are some of your questions and takeaways from this lecture? Any questions? Any comments? Any insights? Any points of critique? Any suggestions? What will you take with you? What will you take away after leaving the classroom? Yes? Super complex. But please, after consulting the study materials, if you have questions, let me know, and I'd be happy to discuss them in class. But I also trust that you'll be discussing in a tutorial session with your teacher, and you'll have the chance to discuss a Whiteman case, which will help to understand better the question and the legal reasoning of the court and how they connect to broader constitutional questions regarding Brexit in connection with the notion of European disintegration, the broader concept of European disintegration. And what else would be the takeaway from this lecture? Apart from the complexity of Article 50, which we already know. It was so complex that there was a need to resort to the Court of Justice for legal interpretations. Tomorrow, we shift perspective. We change perspective. Our focus will be on European integration, illustrated by the case of enlargement. The European Commission has adopted a package within which it has promised an enlarged European Union by 2030. There are a number of candidate countries aspiring to join the European Union, some in the Western Balkans, and other countries like Ukraine, Moldova, and Georgia. What are the perspectives of the member states? Are the 27 member states in synchrony to vote through unanimous decision-making for enlarging the EU with a 28th member state? What are the pros and cons underlying enlargement? Should the EU deepen integration? Or should the EU take its time to actually address several critiques by member states who opine that first the EU should resolve its internal crisis prior to consider enlarging the European Union? Enlargement is largely discussed from different angles: political science, policy, economics. Ours will take a legal angle, delving into the literature and drawing insight from the political science literature as well. Yes?
Well, what is your stance regarding, as a lawyer being, on EU enlargement? Should we enlarge, or say, well, we need to fix our problems first?
I would answer by replicating the favorite answer of lawyers, which is enlargement should be based on merit, not necessarily expanding on geopolitical grounds. So geopolitics, unlike previous ways of enlargement, where geopolitics was not the argument of playing a role in the process, now geopolitics is on the agenda. And lawyers claim that this should not be a reason to compromise the accession criteria of candidate countries to join the European Union. Therefore, should be based on merit, which are assessed against established benchmark on a yearly basis. So this would be a strict legal stance to look at it. However, as suggested earlier, enlargement is a deeply political process. This does not mean that a member state vote overlooking the accession framework. But as we'll see tomorrow, the treaties themselves set some minimal condition, and the rest is laid down in political documents, in soft norms, in soft norms, political guidelines, white papers of the EU institutions.
And do you think that there is right now also the soft norms, because it's broad and it doesn't also tackle or take into consideration the geopolitical?
No, they are not formally legally binding, but they are effective in practice. So from that perspective, they wouldn't be a barrier, but ultimately the decision lies with the Council, with the member states. They have the final say, even though the European Commission may propose enlargement and may be in favor of it, and Ms. von der Leyen is much in favor of it, even though she refers to the merit-based principle. The decision-making power lies with the member states, and they will decide considering an alignment of the national interest with the interest of the EU. Why? Because the Council is an intergovernmental institution. So aligning those interests through unanimity is a real challenge. Thank you for the question. Any other questions before we bring this session to an end? Thank you for your attention. I will see you tomorrow to discuss on a more fascinating topic. See you tomorrow.